and we are here to talk about the 6 most common handbook mistakes we see, which could create risk for organizations. And we at ERA, we work with a lot of handbooks for our members. For those of you who may not be aware, we're a nonprofit HR employer association, and we do all sorts of services like affirmative action plans, employee engagement services, talent development. And near and dear to Melissa's and my hearts, we run the hotline 8 to 5, Monday through Friday, answer lots of questions for our members about HR and best practices and all sorts of compliance things, and answer lots of questions about policies and procedures. And we also work on handbooks, which is a super fun project where we get to learn more about businesses and what our different businesses needs are. And so I'm going to let Melissa introduce herself, and then we'll get right into it.
I'm Melissa Wymer. I am one of the HR compliance consultants.
You going to lunch soon?
And I'll be here a year next week. Woohoo. Prior to that, I was an HR journalist and an HR consultant for one of the largest LGBTQ organizations in Ohio. So that's kind of my bread and butter when it comes to handbooks, making sure that it expresses the culture. And like Rebecca said, I just really enjoy learning about the different organizations we have members and their culture and how they want to transform their handbook. So handbooks, they're a great opportunity. So for me, I am very passionate about handbooks. These are the first things that your new hires are going to be receiving. They're going to be introduced to the handbook. Hopefully they're reading it, or at least they're saying that they've read it. But they'll be able to find all their policies and procedures, how to look up answers to common questions, understand the culture, the mission, the vision of your company. Also, with onboarding and orientation, it can reinforce the culture. As I mentioned, do you showcase all the perks and benefits? Maybe you have a paid parental leave policy and it's not in your handbook. How are people going to know that you have it? Are you trying to create a more casual work environment? Are you going more traditional? Can you access this via software or electronic devices? And then it showcases your commitment to your employees. For me, this is your first shot at with the employee. They made it through the interview process. They made it through orientation. The handbook is going to hopefully keep them and show them that you have a strong commitment.
Thanks. Oh, and also, you guys feel free to chat your questions. We'll take questions during the presentation. So whoever's not talking between me and Melissa, we'll let the other one know that there's a question to be answered. And then we'll also save some time at the end. So we want to be kind of flexible about that. So, all right. So then another thing, a little bit more introduction on handbooks before we dive into the meat and potatoes of this. They really are a great risk mitigator. And I don't know if I mentioned in my introduction, I was an employment law attorney in Columbus for about 13 years before I kind of worked more into this field. So I've seen in the courtrooms and in briefings and all sorts of things I've seen where handbooks can be very powerful in helping to mitigate risk for organizations. One of the first things, and this will be a theme that you'll hear throughout the webinar, is how important consistency is. One thing I told my students, because I also was teaching an employment law class at Ohio State at the Fisher College of Business for 16 years, I always tell my students at the beginning of class, if you don't remember anything else from my class when you're sitting in your office 15, 20 years from now, I want you to remember 2 things from this class: consistency and documentation. because consistency will take you a long way to avoiding or mitigating the risk of discrimination cases, retaliation cases, things like that. Having clear policies help us strive and maintain consistency. For example, we want to state whether unused PTO or vacation time will be carried over from year to the next, or whether that's not permissible at all. Do we have any carryover or do we not? I will always point out when I'm reviewing a handbook where it says, well, it's up to the manager's discretion, or it's up to the president's discretion as to whether someone gets to carry over vacation or unused PTO from one year to the next. I will always highlight that and say, look, this is an opening for inconsistency. And then someone might say, well, I didn't get to carry over because I am a member of an underrepresented class. Next point is that clear expectations on conduct are important. I saw through my litigation experience that juries love fairness. Mm-hmm. They love fairness. They want to see that people knew that they were going to be fired if they engaged in certain behavior. If something is serious enough in your organization to warrant termination, it is good to be able to point to something in your handbook showing that the employee knew about it. For example, we don't want it to be a surprise for our employees. Let's say that someone...
I clicked on join from a calendar. If you click in there, there's a Zoom.
Oh, Rebecca, you're muted.
Oh, okay, you muted me too, Melissa. It's okay.
Sorry.
So anyhow, so let's say that an employee swipes someone else's time card before that person arrives, and then they end up getting disciplined or potentially even fired for it. And then they go to the jury when they're going for their discrimination or unlawful termination case, and they say, well, I didn't know. And we think from HR, we think, well, it's common sense. You don't do these kinds of things, but it gives the employer additional grounds to win their case with the jury if they're able to pull up that handbook, have it as a big exhibit, say you knew that you can't be doing this, you knew that falsification or fraudulent, XYZ could be grounds for termination. And then it's also good in a handbook to be aware of any legal landmines so that we know that the handbook is actually a help and not a risk. So a couple of biggies, and we'll be talking about them both throughout the presentation. So I'm just going to touch on them super quickly. Sexual harassment claims, we need to carve them out of arbitration agreements. And then also we need to pay really, really close attention to the National Labor Relations Act. And we have a whole section on that later. So I'm going to test this exercise. If you can grab your phone, and unless you're on your phone right now, and take this QR code, and let me get the link up. I think I have to do a new share to get it, and then type in, what part of your handbook causes you the most concern. And I hope this works. I'm going to test it out myself too. And it should, if it works, it should create a word cloud. Oh, great. So we're seeing a lot here. Thank you for adding your thoughts. Inconsistency, PTO, needing updated, don't have one, remote, inclusive for in-office plus. Very cool. Mm-hmm. All right, I am going to go back to the presentation. Okay. And new share. Thank you for bearing with me. Okay, great. Thank you guys. I really appreciate that. All right, so here's a quick, and I'll just spend 10 seconds on this. This is just the overview of the 6 things we're about to jump into. So we're going to start off with talking about harassment, and I'm going to toss the baton over to Melissa again.
So harassment, it is the employer's responsibility to let employees know what harassment is, what to do if it happens to them or another coworker, and how the supervisor or the company can prevent future harassment. We expect in the handbook, or at least your employees inspect in the handbook, what is the procedure the employees need to follow to report an incident of harassment, including the specific person to whom an employee should report, the alternate person if that designated person happens to be the alleged harasser. The questions that you have to think about is like, did the company know or should have known but failed to make the prompt or appropriate corrective action? For a supervisor, we have the affirmative defense if there's no T and the company had made reasonable efforts to prevent and correct harassment while simultaneously the individual unreasonably failed to take advantage of those efforts. You want the strong anti-harassment. It needs to be very clear. Ones that I've dealt with automatically says you go to HR. Well, you go to supervisor. If your supervisor is not doing anything, you go to HR. If your supervisor happens to be the person that is harassing, go to HR. We even had compliance department on site, so we threw that into the mix that if you didn't feel comfortable coming to HR, you could go to our compliance officer, who is also a lawyer, to help with that. So you need to be very clear that you'll take action on any incident which violates the company policy. Don't limit it to just what happens at the workplace. Remote incidents of harassment or discrimination. If your employees are at a customer site or at events, what's the plan? What's the process? Don't just limit it to supervisors. Coworkers and subordinates can be policy violators as well. And third parties such as vendors, delivery drivers, customers. I even had to do a sexual harassment training because the person delivering the mail was harassing our staff and talking to them about what we're going to do as an agency to protect them. Also, it's not just sexual. You have protected characteristics such as disability, race, national origin, gender identity, sexual orientation, age, color, military status, and so on. So pretty much anything that you see in an EEO statement, as long as it's updated, is going to be what is protected under harassment. For example, we would have teasing someone because of their accent, or if they have a mental illness. I've also had situations where it's involved gender identity and sexual orientation. And I had someone say, well, the person was transitioning from female to male, and another employee happened to look at the transitioning person and said, well, why don't you just use your male brain to figure that out? I've also had situations where people have said, I hate straight people. And we're a protected class, even if we are the largest, even if I was working for the largest LGBTQ health organization. Not everyone will understand the term the same way. There's been times where harassment has been thrown around and it wasn't harassment. So going through and asking the employee, what do you understand as harassment? And what does it look like to you? That way you can help understand and maybe educate them on, this isn't harassment, this is more bullying, or it's still a problem, but it's geared more this direction rather than harassment. Sexually suggestive language, touching in inappropriate places, teasing about the protected characteristics, showing any kind of pornography, making offensive comments based on race, color, again, going back to the EEOC, taking pictures of people's body parts. You don't have to spell everything out because if we did, you probably have at least a 200-page handbook that definitely no one will read. But you should give enough detail and have a catch-all statement so your reader understands what the general issue is. For consequences, you want to make sure that you have what's going to happen to the employee if harassment occurs. Termination should not be a surprise if something happens. Let people know that there's going to be an investigation. The catch-all phrase of, discipline up to including termination is kind of seals the deal for a lot of policies that individuals violate. For your complaint procedure, you should always have multiple people to report. Don't give names since a lot of people change roles, but give titles such as, your supervisor or direct supervisor or the head of the department or HR. That way it helps give people options, especially if their supervisor or someone close to them is the harasser and they're like, I don't feel comfortable with this person. I don't feel comfortable with this person. Then I'm just not going to report it. And then you're going to have a bigger problem on your hands. Never require or strongly suggest that the person first take it up with the offender. There's a time and a place for both employees to have a conversation with each other. Harassment's always not one of them. It's not a time for mediation. It's a time for you all to take action and investigate and correct the issue. Never require them to go straight to their supervisor first. The supervisor could be the offender. They may not have a great relationship with their supervisor. I've had situations where they came directly to me and I'm like, hey, did you talk to your supervisor, just to gauge who knows about this, rather than, oh, I'm sorry, you need to go here. Working in HR, I've always told the employees, you can come to me and I will help assist you in any way. I never really forced them to go talk to anybody else because they came to me and they're reporting and I need to tackle it. And I would provide avenues to correct the issue. Never require them to only provide their complaint a written statement. You can encourage it, but some people don't want that pen to paper. And they're coming to you and you know about the situation, you need to handle it. You don't need to wait for them to fill out this long statement just for you to do something about it. And then always assure there's no retaliation. Many employees tend to stress about reporting the situation because of, retaliation. So then it becomes, we can't fix problems in the workplace if we don't know it. I've told employees that before. If you don't tell me what's going on, I can't fix it. And then you're stuck in this place and it's not a good place for you to be in. And then policy must advise them from the outset that we will not tolerate retaliation and anyone engaging in it will be subject to discipline. So after I've talked with the employee, I've always stated, we do have a no retaliation policy. If something's coming up, tell me immediately. That way I can handle it. So those are just some things you want to think about for your harassment policies. So accommodation for Rebecca.
Yeah. So before we move on, does anyone have any questions for Melissa about harassment policies? If you are, I'll let you know too, if you want to email me at rjacobs, RJACOBS at erahr.org, I will be happy to send you our sample harassment policy if you want to take a look at it and maybe compare it to what you have and things like that. So I'll put my email in the chat. It's at the end too, but while I'm thinking about it, I'll put it in here. All right. Okay, so moving on to accommodation. This is actually one of the biggest misses that I find when I'm reviewing handbooks. It seems like a lot of organizations put a lot of emphasis, as they should, on their EEO policy, anti-harassment policy, their drug-free workplace policy, no smoking, so on and so forth. But then there's really nothing in there about what if an employee needs an accommodation. So I'm going to talk through through a refresher real quick on why it's important to have it, and then talk through a few of the key things that we want to see in it. So as a refresher for all of you, the Americans with Disabilities Act requires employers to engage in the interactive process, which means essentially like a back and forth discussion with employees when those employees have come to them and said, I need a change at work because of a disability. And disability means a mental or physical impairment which substantially limits a major life activity or having a record of that. And the Americans with Disabilities Act further says if someone has a disability and if they need a reasonable accommodation in order to perform the essential functions of their job, then the employer must, work with them to get them that accommodation so that they can do it. So for example, let's say that you have a retail operation and typically you have your retail clerks, your cashiers standing and running the items over the little scan thing to beep, and then it's putting the price in the point of sale thing. Anyhow, so as they do that, they're typically standing, reaching, so on and so forth. And maybe you're used to everyone standing, but someone perhaps has a knee problem or a foot problem. They're limited in the major life activity of standing. What would typically happen in a perfect world is they would go to HR or start the conversation with their manager, who would then hopefully direct them on to HR and say, hey, I need help. I'm having trouble standing and doing this because of my medical condition. So then HR knows, hey, we're starting the interactive process now. So then they say, okay, well, I need substantiation from your healthcare provider of the existence of a disability, as well as why this accommodation is needed. So in other words, we don't have to take the employee's word for it unless it's obvious that they need it. So then the employee goes to their doctor, they get their healthcare provider, they get the information, it comes back to the employer, and we kind of work out, okay, well, what's going to allow this person to do the job? If it's an essential function in the job description that you must stand for whatever reason, then having a seated position, like maybe a stool, may not be the best thing. But maybe the doctor says, well, they need more frequent breaks. Well, maybe that would be the accommodation. But the bottom line is, it's actually a requirement in the law for the employer to go through this process, the interactive process. And so what we need to do is we need to make sure that employees know exactly how to start the process, because we don't want to be in a situation where an employee says, well, I mentioned to my manager that standing hurts, but nothing ever came out of it. And, did the manager know to ask the question, well, how can we help you, in response to the employee complaining about something? If not, and if there's no policy saying this is how you start an accommodation, then that could lead to an ADA charge or potential lawsuit from the employee. So what we want to do is we want to have that accommodation policy in the handbook. I usually put it right after the harassment policy, like towards the beginning. And we say, we are committed to ensuring that all employees have what they need to be successful at work. We're committed to realizing the vision of the Americans with Disabilities Act for all employees, regardless of their challenges, so that they're able to perform their jobs. And because a lot of employees may not be aware of the Americans with Disabilities Act, I include some of the possible accommodations. Like maybe you'll have a change to your workstation, a change to schedule, a change to the medical leave policies. I also like to make sure that we have inclusive wording that we're saying individuals with disabilities instead of disabled employees. And most importantly, let's point out in the policy how to request an accommodation. Of course, we're not going to hold their feet to the fire if they don't do it perfectly, but at least this is encouraging them to have that conversation. So what I typically like to do is have something that actually identifies who they should talk to. So does your organization have maybe the opportunity to have maybe an email account? That would be accommodations@employer.com or hrhelp@employer.com. The reason I love the idea of having an email account for accommodations@employer.com is that the Americans with Disabilities Act also applies to applicants. So in your application process, and perhaps even in your LinkedIn job ad or whatever, if someone needs an accommodation to put in their application, there's an email address for them. So they can email that and say, hey, I need a different kind of, or I need this specific thing for my application. So that's a best practice in that. And with that, I'm going to move on. We have a quick poll I'm going to launch. Okay, so if your handbook has an ADA or accommodation policy, does it give contact information for whom to request an accommodation? Yes, no, not sure, and no ADA or accommodation policy. So we'll leave it open for about another 20 seconds, and then we'll see how everyone answers. All right, I see we still have a few people answering, so I'll leave it open just for another few seconds. All right. So it looks like about 40% said yes, they have a contact information. So that's awesome. 56% say not sure. And then 4% say no ADA or accommodation policy. All right. Moving on. This will only take a moment to touch on, and then I'll pass it back to Melissa. So arbitration agreements have been hot and heavy in the news over the past couple of months since the federal Congress passed a law saying that we cannot force employees to arbitrate sexual harassment claims. Now, what exactly is arbitration? Arbitration is a process where we resolve a dispute outside of court. And the agreement is a contract, and it's a contractual obligation for the employee to go through the arbitration process, which can be much quicker and cheaper than court. So in other words, you still get to do some discovery where you're exchanging documents, you're interviewing or deposing the other side to gather evidence. But at the end of the day, you go in front of one person who's going to listen, hear everyone's side of the story, and render a decision, as opposed to the very lengthy, very, very expensive in terms of attorney's fees, court process, where you now have a jury where there could be some very strong emotions, which could be informing the ultimate verdict against the company if the person wins. So employers love arbitration agreements because it's a nice way to contain costs and reduce some of the unpredictability of those jury verdicts. Employees and their attorneys hate it because for the exact same reason. And the bottom line is that these really are supposed to be contracts. And a handbook is not a contract. We should have disclaimers in the handbook that say you're an employee at will. The company can terminate your employment for any reason at any time that's not contrary to law. And the handbook is not a contract. There's nothing in here that is a contractual obligation on the part of the company. So we can't have that kind of contract disclaimer in the handbook and then also throw in our arbitration agreement as like a policy and have them, acknowledge the handbook. The arbitration agreement at that point really has no it's not even worth the paper it's written on at that point. So you want to have a separate agreement for arbitration. But if a company is doing that, at this point, they have to carve out those harassment claims, because we cannot take those into arbitration. Those have been carved out federally, and we just cannot do that. So I'll toss it back to Melissa.
So we're going to talk about employees in other states. So if you call us and would like us to work on your handbook, you're going to hear us ask, what states are you in? And we're going to pray that we don't hear New York and California, but we will do New York and California if you're in those. So when you're doing your employee handbook, I always tell people that I'm working with that if you're a multi-state employer, your handbook that you're handing to everybody is going to be a very generic handbook. And what I mean by generic, it's going to focus more on the federal laws rather than, oh, I'm in this state, or, my headquarters is in Ohio, but I have people in the following states. The reason for not basing it off your headquarters is each state's going to have a different law or requirement for employees. In Ohio, the employer has a handbook provision that all unused PTO or vacation time, however you call it, is forfeited upon separation of employment. It's really up to the employer whether or not they're going to pay out that unused time. It's not required in Ohio. However, in California, it's a whole different ballgame, and it would be illegal to do so. Other common areas of conflict between multi-states is deductions for paychecks. There's only certain things you can deduct from a paycheck. Whether having weapons in parked vehicles is going to be different across the states. Requiring direct deposit as opposed to pay cards or checks. Drug tests, that is definitely another big one. We have, certain locations that do not allow testing for marijuana. Other things is bans on asking about prior compensation. California, Connecticut, Massachusetts, Oregon, just to name a few, ban employers from asking applicants about their compensation at their previous jobs, and suggest that when you have an online application, instead of having 6 different ones for whatever state, you have one application and you just take the question off. Mandatory paid sick leave, Arizona, California, Connecticut, Maryland, Massachusetts, Michigan, again, just to name a few, there's far more than that, require employers to provide some sort of pay leave. The differences could be accrual rate, the carryover obligations, the minimum increments. I've seen for some states where an employee gets 1 hour of paid leave after working 40 hours. So it's 1 paid per week, essentially. Some states may have additional entitlements and requirements to notify employees in writing. South Carolina has something about posting notice about pay frequencies. And then supplement, we always suggest having a supplement or an addenda for each state. That way you hand the generic, the comprehensive, however you want to call it, handbook to the employee. And then based on that employee's location, you give them that state addenda. Do not give all the state addendas to everybody because it's not focused on them, and they're going to be like, oh, heck, I want to move over to California because I'm going to be entitled to 20 different other paid leaves. Or why can I not use this, or think that they can use it and it's not an entitlement in their state? And then it looks like we have another poll. There we go. So before I get into social media and the social media policies, we're having a poll about has your organization had to counsel or discipline an employee for their off-duty social media activity?
And while we're waiting for people to answer, I want to comment that I love that the picture we have on the screen is of someone taking a picture of their beautiful meal, probably to share on Instagram.
Yes. I mean, it does look like a very delicious dish. That's photo worthy. I know my husband gets annoyed when I'm like, hold on, don't touch. I need to take a photo of this.
All right, we'll give it another 10 seconds and then we'll look at the results. All right, we're going to share the results. 48% that they have said that they have not had to counsel or discipline an employee for off-duty social media activity. 35% said yes, so a third of the people on here have had to. And then 16% are not sure. So thank you for participating in that. And I will turn it back over to Melissa.
Awesome. So social media policies is probably every company's nightmare. Just because there's so much that you want to do as an employer, and little do you know, there's not a whole lot you can do as an employer. So we have, the tweet that was heard around the world. I know Rebecca and I absolutely love this situation with Justine Sacco. She, just to give a backstory, if you don't know, she made an AIDS joke when she was traveling to Africa. And she said, I hope I don't get AIDS. Just kidding, I'm white. And her boss was like, that is very outrageous and offensive. And, it ended up becoming a hashtag. So some people were so outraged and wanted her fired that it became one of like the top 10 hashtags for, I think, for the week. We hear about other, mostly celebrities, making some inappropriate conversation or, inappropriate tweets. Gina Carano, that she was in The Mandalorian, she's an MMA fighter. She lost her job and was not added into the next season of The Mandalorian due to some of her tweets. We also have Nicole Crowther. She is an add-on to Glee, if you ever watched Glee, and she leaked a few of the scenes that were upcoming, and kind of was like the spoiler for the situation. And Ryan Murphy, who created Glee, was not happy and pretty much said, hope you're qualified to work in something besides entertainment. And she did have a very hard time getting any other castings for entertainment. So employees, other issues that we see that employers try to add into a social media policy is we have employees may not use their social media to release confidential guests, team member, or company info. Now, employees have the right to discuss and disclose information regarding their own conditions of employment. Employers try to add language such as employees must be sure that social media posts related to the employer are completely accurate and not misleading, and that they do not reveal non-public company information on any public site. The term completely accurate and not misleading is overbroad because it would reasonably be interpreted to apply to discussions about or criticisms of the employer's labor policies. Another thing that I see is employees should think carefully about friending coworkers on external social media sites. That language is overbroad because it's discouraging communications among coworkers. Many companies like to try to prevent employees from saying negative things about the company on social media, but limiting that or prohibiting employees' speech could reflect negatively on a company and could violate the employee's rights under Section 7 of the National Labor Relations Act, which Rebecca will get to after this. Suggesting that employees add a disclaimer to their post that opinions of the employee expressed on social media are the employee's own and do not represent. I've seen that in a lot of policies, and that's a way for employees to still have that freedom of speech, be able to discuss things, still be protected under Section 7, but stating that this is not the views of my company, where I came from prior when it came to topic about marijuana or any sort of policy that was against LGBTQ or laws. People could say whatever they wanted, but as long as they didn't say, Equitas Health believes, because Equitas Health wanted to provide their own statement. The NRLB, which I found interesting, reviewed 7 employer social media policies. It was just 7 random throughout the United States. They found provisions within 6 of them to be overbroad and thus unlawful because they interfere with the rights that are protected under the National Labor Relations Act. So 6 out of the 7 were unlawful. That blows my mind. And that just shows how complicated social media policies can be. Are they needed? Yes, but you have to tread lightly. It does become a very gray area when you're messing with the National Labor Relations.
And on that, I'm going to talk about the National Labor Relations Act. So as a refresher, Section 7 of the National Labor Relations Act says that employees have the right to engage in concerted protected activity for mutual aid or protection, which essentially means that they're working together or by themselves, but on behalf of each other to improve their terms and conditions of employment or otherwise improve their lot as employees. So this applies to companies if they have unions, and it applies to companies if they don't have unions. It applies to everybody. And it's really, really the only limitation on it is it protects non-managerial employees. So we have to be very careful not to have anything in our handbook which appears to inhibit or threaten potential disciplinary action for any of this protected concerted activity. So what kind of things, what kind of policies do we need to keep an eye out for? So when I do a handbook review, that is always something, as I'm reading each and every single policy, that's always like the one of the lens that I'm reading through is there anything in here that could potentially violate or be seen to chill those Section 7 rights? And I'll just make a quick note to recognize that with our new administration, or I guess it's been a couple of years now, but with the Biden administration, the board is becoming more employee friendly, and they're pushing for more protection. So during the Trump administration, the board was starting to swing, especially with handbook policies, a little bit more towards, well, let's have this very structured test and balance legitimate business reasons with of the policy with how it's going to impact the employee. And essentially everyone has told us, even though there hasn't been a decision on point yet to kind of create that new piece of law, which is how the board works. But everyone is expecting that the current makeup of the board is going to go back to the previous test under the Obama administration of does it potentially chill someone's exercise of that right to try and make their terms and conditions of employment better. So this was a gem which was circulated on the picture here, circulated on a lot of websites. It's a sign which was put up in a break room, effective immediately. Conversing about wages, both on duty and on off duty, is strictly forbidden. This is considered proprietary information, and as such, it is protected legally. If you are overheard speaking or listening to a conversation in which wages are discussed, you will receive disciplinary action up to and including termination. As a reminder, Kentucky is an at-will state, meaning that your employment can be terminated for any reason without legal repercussion or no reason. Have any questions? Ask Jer. So this is very illegal. And I've seen in some older handbooks, I've seen policies where maybe it's in the confidentiality provision where they say do not discuss wages with each other, or they'll just have a standalone policy in the handbook that says do not discuss wages and salaries with your coworkers. Now, obviously, I understand the desire to have wages and salaries cloaked in secrecy because, I mean, pay compression, maybe a manager is only making a couple $1,000s more than someone who they're managing, and I don't know, but probably the manager would know what they're making. But anyhow, so that's probably a bad example. But the point is, employers do want to have some control over what people know about what everyone else is making. But the bottom line is we cannot stop them from talking to each other. That in a policy would be a huge problem. Other places where it can come up, no gripe rules. Maybe it's in social media, as Melissa was talking about, or maybe it's somewhere else in the policy where we're talking about civility, where it says, don't make negative commentary about other employees or the company. Don't, because we see that a lot about, companies wanting to prevent their employees from portraying the company in a bad light, and say don't say anything negative about the company, don't hold the company in a bad light. But the thing is that if an employee has a problem with something at work, whether they feel maybe their wages are not up to par, or there's a safety concern, or they feel like the manager is not engaging in appropriate behavior, they have the right under the National Labor Relations Act to talk to people about it, to talk to people inside the organization and to talk to people outside the organization, because that's how a lot of the union activity begins. As employees start talking, and maybe they get connected with an organizer, and then the organizer is able to ask the employee, well, can you get me information about other employees who are in your department? And the employee has a right to share that information. So we can't even have a policy in our confidentiality provision saying, you are prohibited from sharing employees' names outside the organization, because the employee has a right to do that under the National Labor Relations Act. Mm-hmm. So it's really important to pay attention to all of our handbook provisions to make sure that we don't have any of these problematic statements in there. Another thing that I see as an issue is where we have a policy like maybe bulletin boards or something like that, where, or maybe the company has those TV screens throughout the facility, and they're flashing like, okay, here's our stock for today, or here's the weather for today, and then here's employee safety meeting, and then, oh, I'm going to ask them to share, come to my part of the building because I've got some Girl Scout cookies to sell, or things like that. So the question is, are employees allowed to share their non-work related items on these different venues or in these different means? And a lot of companies will say, well, employees are able to post information, but they have to get approval from HR or approval from the president first. And for me, that's a big red flag. Mm-hmm. Because if there's any potential inconsistency, it's like, oh yeah, I'm going to allow the posting about Girl Scout cookies, Boy Scout popcorn. Oh, there's one about a union meeting. Definitely not. So if that kind of a rule is applied with a union animus, the National Labor Relations Board is going to be all over that. So what I like to do is I like to take a little bit of a harder stance on that and just say, employees don't need to be posting these things. We're not going to have Girl Scout cookie sheets posted on our bulletin board in the break room. Instead, if employees are like, oh, I want to be able to, drum up some business for my kids, say, well, talk to your friends, talk to your friends about, hey, if you want Girl Scout cookies, come by. But we just don't want to have, as soon as we open the door to allow posting for these other non-work related things, then we're going to have to allow the union related ones. So mindful of time, we've got 10 minutes. Also want to make sure we have a few minutes just to sit and be quiet and listen for any questions. So the last thing I wanted to talk about is about the language and making sure that the language of your handbook is easy to read and to understand. And the biggest issue that I see inside of this topic is ambiguity. And the problem with ambiguity is that if something can be interpreted in different ways, it can be applied differently by managers to get inconsistent results. And if we have inconsistencies, again, that opens the door for someone to say, well, the reason I didn't get my vacation request approved was because of my membership in an underrepresented group, whereas a manager might say, well, no, I just have a different way of doing this than this other manager in this other group. But I wanted to also give you a few examples of policy language that can raise questions and lead to ambiguities. So for example, like knives, firearms, and other hazardous devices are prohibited from the premises without proper authorization. So what I want to know is, when I'm reading the handbook, I'm going to ask you, what does proper authorization look like? Is it verbal assent from a manager? Is it written permission from human resources? Because we don't want to have a person bring a weapon in and then claim that their manager told them that it was okay. For something like that, I think I want that authorization to be in writing. So I would revise a policy to say prohibited from the premises without written authorization from, and then I'd say, human resources or president or CEO or something like that. Also, sometimes we have ambiguity in omission. For example, maybe we have a line in a drug-free workplace policy where it goes through the whole thing about, here's when we test, here's what we test for. And then the part where it talks about what's the consequence, it says individuals who receive a positive drug test result will be subject to disciplinary action up to and including termination. Well, what about a person who provides a diluted sample? What about a person who provides a sample at room temperature? What about someone who has obstructed the process? If we don't have anything in there about, what are the consequences if someone is kind of messing with the whole drug test process, then we're going to have to rely on something outside of the drug-free workplace policy. Like, can we argue that that's in the misconduct policy? So what I like to do is I like to include language in the drug test policy, which specifically says, if you obstruct the drug test process or provide, there's some good language in it about, about the sample, then that would also, that some people will say that'll be treated the same as a positive test result, or some will say it will be subject to disciplinary action up to including termination. So the question is it specific enough to enable consistency and ensure the proper procedures are followed? And then is it enough to give that sufficient notice to the employees that this particular conduct or this particular action could lead to employment disciplinary action? And then lengthy procedures. One thing we like to do is we consider the purpose of the handbook. And the purpose is to have employee-facing policies, which all employees need to know. So we often will find in handbooks that there are these long procedures in there which only apply to a certain subset of employees. Like for salespeople, here's your expense reimbursement policy. Well, not everyone needs to have that. So do we want to carve that out and have like a separate procedure document for our salespeople? Or maybe it's an internal procedure such as how you do your orientation. Well, by the time a person is reading your handbook, they're actually in the orientation. They don't really need to know about all the things that go on before the orientation. So what we typically do when we review a handbook is we ask at the outset, is it okay with you if we point out those things in your handbook that seem a little inefficient to be in a handbook. These procedures which aren't really technically employee facing. So with that, I have 5 minutes left in the webinar, and I wanted to give opportunities for questions or anything like that. Oh, and feel free to connect with me on LinkedIn. I know Melissa's on LinkedIn as well. Feel free to send me an email if you have any questions. I go to the next page. I'm going to put the SHRM code in the chat. And I also wanted to mention that you're going to get a follow-up email on Monday from ERA. We are going to provide a 10% discount on our handbook review services for anyone who has attended the webinar. So wanted to make that available as well. I'm not seeing any questions coming in through the chat. Melissa, any final thoughts as we see if anyone's got a question?
I'm trying to think. Not really. One thing that came up was about failing to train on the handbook. You have any insight about training employees on the handbook, best practices?
I like to carve out time during the orientation to like go through and like take the ones that are really important, like super important, that have like more legal significance, and make sure to really go through those, like the accommodation one, the harassment one, drug-free workplace, the misconduct. So I think that some of the other ones, I might not be like, really going over all the points with them, but just referring to them to read it over and make sure they're familiar with it, and let me know if you have any questions.
We did get another question. What if our more legal policies are in the appendix? Is there a best location for those policies?
So I guess I'm curious as to the meaning of the legal policies. If it is the things like the harassment, the accommodation, that's kind of what I think of when I think of legal things. I want those in the front.
Yes.
I want them front, center. Some of the usually I first have the at-will disclaimer, and then I've got the EEO policy, and then I've got the harassment, the accommodation, the GINA, the I-9. I have all that. Let's see, a binder is perfectly fine. You can have a policies binder, no problem with that.
Yeah.
And it's fine too if you have everything on your intranet. Just make sure that you've documented that people know how to get there and they have the link and all that.
Yeah, we had our handbook on the program we used was Compliance Manager, and that's how we would attest to it. And then we would, anytime there was changes to it, we would go back in and attest to it. And that's another big thing, is any changes need to be signed by the employee, recognizing that they know that there's changes and these are the changes that have been made. Also, don't apply the changes if you have to have some board approval. One situation at my old job, my boss was like, well, this is the policy. And I was like, but the board hasn't approved it, so you can't hold the employees to that. So those are just random things to think about.
Great, thanks. And just as a quick reminder, I think I already have some emails that have rolled in, and I'll get on those right away. If you're interested in looking at our sample harassment policy, email me and I will reply with that for you. It'll be in Word document format, so you can copy and paste to your heart's delight. All right, well, with that, I think we're going to go ahead and stop, but you have my email address. If you have additional follow-up questions, be happy to answer those. Either Melissa and I would. So, okay, Susie, got it.
Thank you, everyone.